is a company secretary who was company secretary with Luxottica and thereafter with Hero Cycles, and is working together with us on the issue of compliances. And he will be primarily dealing with the issue of compliances, whereas I would be dealing with the issue of the legal health check. Now, why this issue is necessary and why this topic? You see, most of you would be wondering why we have chosen the topic legal health check. You would have heard about health check, comprehensive medical health checks, and large number of companies are advising their employees to go in for comprehensive medical health checks. And why is it so that they are doing it? It is not because they intend to throw out employees who are found to suffer from a disease, but for the reason that healthy employees would be more productive, and if someone knows that there is likelihood of any disease to develop, he or she can take preventive steps and thus save on costs that they are likely to occur on major surgeries. Moreover, the emerging scenario in which this country has witnessed various financial scams, ranging from banking scams, pyramid schemes, chit fund frauds, to shareholders' money being at stake. The various regulatory agencies of the government are increasing the web of compliances. The time when the compliances had to be manually compiled are over. Now, even a single click Now, even a single default pops up on the computer within seconds, making the companies and their CEOs and officers in default vulnerable. Similarly, a large number of large corporates, fearing exorbitant legal costs, will take a toll on the financial, managerial, and administrative health of the company, are considering that it is better to go for a comprehensive legal health check in order to, if not completely avoid, than to reduce future litigation costs. It has become all the more important as a number of changes in laws have made the responsibility of the promoter directors and the managing directors, CEOs, and OID even more vulnerable and expose them to higher penal consequences, including imprisonment. With the introduction of a provision for having independent directors on the board of directors, even the talented independent directors would feel more comfortable on, on coming on the board of directors of a company of which they have reason to believe that it is completing its compliances and they are legally secure. I would also like to deal with this issue in the context of the Indian economy. The corporates are passing through tough times for the last couple of years. The Indian economy was battling with an economic slowdown before it was hit by the lockdown on account of the impending spread of COVID 19. Even though the steps have been taken by the center and state governments for opening up of the economy, but the same can only be considered as baby steps, and it cannot be said that the worst for the economy is over. Most of the economists were expecting that the government would announce more bold measures for boosting the economy, but the government seems to be battling its own demons on the economic front. The condition of MSMEs is a lot worse. The expectation from the courts has not yielded the desired results. One fact which has been again highlighted is that the general clause of force majeure will not be sufficient to deal with the situation. And ultimately, it is the specific clauses of the contract between the parties will be most material, and the contract has to be drafted within legal parameters. Day by day, we are entering into a more complex world. While the buzzword may be ease of doing business, but in reality, every entrepreneur will tell you that doing business is becoming more and more difficult. There are so many compliances to be undertaken, and if a corporate head has to personally look into all the compliances, he or she would have no time left to do anything else. Having the right contract with well defined parameters can be of help to corporates as it would reduce the litigation which the parties may be compelled to enter into. Moreover, a well defined contract would give a better idea with regard to the likely outcome of the litigation so that the companies will be in a better position to make an informed choice. One of the facts which have also been highlighted during the pandemic is that the standard formats, whether prepared by the typist sitting in court complexes or those downloaded from the internet, cannot serve the purpose of the specific need of the industry, and every industry has its own peculiar problem, and one size fits all may not be suitable. It is usual in the real estate industry to go in for due diligence whenever any company intends to buy property or take a new property on lease. Usually, this is done because the government this is done because the investment in property involves huge investment. But why do it for leased property? You see, it is understandable if you're buying a property, you're making a huge investment. But why do they do it for leased property? Because even in leased property, investment is done for the interior work, and once you have done a setup, once the business has been set up, then shifting from one property to another property may not be a very feasible idea. And similarly, by the same logic, if the property is to be vacated before completing the full term, then this investment goes waste. Similarly, any abrupt disruption in the contract for whatever reasons is likely to have a disruptive effect on business, and thus the attempt at all times should be to reduce all likelihood of the problems. In the legal health check, it is usual to examine all contracts that may have been entered into with the vendors, suppliers, dealers, distributors, workers, employees, managerial personnel, bankers, NBFCs, financial institutions, and sometimes even promoters and shareholder agreements. An emphasis is also given to examining if there are any areas of conflict of interest. The legal health check for corporates is the need of the hour. Sorry, there was a disruption. I hope you're being able to hear me. No?
hear you, Mr. Ahuja.
Yeah.
Sir.
Are you able to hear us?
Yeah, now.
Please.
Yes.
So the spread of COVID-19 throughout the world has thrown up new challenges and brought to the fore new issues before the corporates and individuals alike. In this discussion, we would like to focus on the issues it has brought to the fore regarding the corporates while leaving aside the issues and challenges for individuals for the time. Just for the beginning, two of the prominent issues which came up before the Honorable Supreme Court and similar issues also came up before the various high courts were one, which was whether the industry of the corporates are liable to pay the full salary even for the period during the lockdown as mandated by the government at that particular time. Two, when there is complete lockdown and offices cannot be opened, are corporates liable to pay rent to the landlords? Both the issues were debated and decided by the Honorable Supreme Court. And you'll find it surprising that on both the issues, the opinion of the Honorable Supreme Court is at a slight variance. On the issue of full salary, the Supreme Court was of the opinion that no, the corporates cannot be held to be liable to pay full salary, especially when there was no work which was going on. On the other issue of payment of rent, the Honorable Delhi High Court and subsequently the Honorable Supreme Court held that force majeure clause cannot be invoked when there was temporary disruption of work. There can be a number of arguments both for and against these decisions, and it cannot be said conclusively that this is the end of the matter, and the Honorable Supreme Court will not be debating on this issue again, as presently some observers believe that there is lack of consistent approach on the part of the Honorable Supreme Court. As while it wants to give some relief to the borrowers of bank loans who have availed moratorium, if not on complete waiver, then maybe partial relief to interest part, even if it is by persuading the government to do it. On the other, it is taking the view to not to interfere in the government policy making. While its logic that if a corporate does not have income on account of government action or socio-economic condition, then from where it is going to pay interest, and that too compounded interest holds merit. On the other, not applying the same logic to private players defies reason. Resultantly, there is likelihood of lots of disputes arising in future if the pandemic is not soon brought under control. Issues like why pubs and restaurants be compelled to pay rent, interest, and taxes when they are not being permitted to open and function on account of government policy. Should the pubs, hotels, restaurants, gyms, banquet halls, and other organizations which are not being permitted to open and function be compelled to pay house tax, electricity, water bills, even at minimum charges if they are not functioning on account of the prevailing circumstances and for circumstances beyond their control? Same is going to be the issue with startups. Recently, there was a report which said that, I think it was today only, that around 33% of the startups, they are in dire straits. Around 12% have already closed down. And most of the startups, around 25% or so, they don't have money to go beyond a period of 3 to 6 months. So in these circumstances, what should be the policy and how it should be dealt with is something which will have to be grappled with by the Supreme Court as well as by the government. A major issue also likely to arise is that the migrant workers who were forced or opted to flee either for the reason that the management or owners of the corporates did not pay them or the fear psychosis was such that they feared that they would die uncared for in a little known land away from their family or near and dear ones in their village? Would their going back to their native villages, bearing all odds, be considered to be an abandonment of work? Or even in those circumstances, the corporates are required to fulfill the norms of industrial dispute law. The Honorable Supreme Court has said in judgments that clause of force majeure in case of temporary disruption of work does not give justifiable reason for invocation of the clause of force majeure. What period can be classified as temporary will also need to be what period can be classified as temporary will also need to be defined. When major areas continue to be closed and economic activity, whether in all fields or certain fields, depending on whether they are classified as red, orange, or green spots, even a closure for a 3 or 4 month period will not mean that economic activity will resume at full swing once the classification is changed. Now, being lawyers, we are also at the receiving end since the courts are closed now for almost 4 months. And so the issue will have to be decided also that how the lawyers are going to survive, along with and whether if you are liable to pay rent and electricity charges and other charges for maintenance of the chambers when you are not being able to or are not being permitted to open the chambers, then what is going to be the effect of it? However, one thing is evident that the definition given by the Honorable Supreme Court that force majeure clause cannot be invoked where disruption is temporary and tenants are not being able to use the premises, but still the tenants are liable to pay to the landlords, which can also be extended to the other fields by same logic, would mean that it is the need of the hour that a specific provision is made in the contracts that the corporates are entering into with various business entities to the effect that provisions and clauses are added as to what would transpire if a similar situation arises in future. I would just like to elaborate here a bit with regard to like even in where you are entering into contractual deals and you are not in a position, let's say, to supply goods. Now, whether the clause of force majeure which has been considered by the Supreme Court in the context of payments of rents would be applicable with regard to the non-supply of goods on your part. If it would be, then in what circumstances and how it would be applicable. The second also is that supposing you are able to supply the goods after or you have to purchase goods and they same cannot be purchased or cannot be delivered on account of the lockdown. And after the expiry of lockdown, the contract which you have entered into for purchase of goods, if it is implemented, it will result in loss to you because you may not have the requirement of those goods at that particular stage. Now, can you say that it is on account of force majeure? If the Supreme Court says that no force majeure is not going to be have effect if it is a temporary lockdown, then what is required is that in future, all future contracts, there should be specific provisions which are made to say that look, this on effect of any temporary disruption of work or on effect of any such situation which results into work being disrupted, although it may not be covered within the definition of force majeure, then also you would have an exit clause by which you can get out of that particular contract. In these circumstances, it is extremely necessary that the companies go in for legal vetting of their agreements so that the agreements can take into consideration the specific industry conditions and prevailing economic situations and the situations which are likely to arise. Legal health check may be considered more as a legal audit, in which you can identify the possible trouble areas and can take remedial action. And if not anything else, at least know which are the trouble areas and make provisions or be better prepared to handle the problems as and when they arise. Now, I would be handing over the uh, mic and would be requesting Mr. Harvinder Singh to speak with regard to the compliances. And thereafter, we would be taking questions and we would try to answer whatsoever your queries are. Even after that, also, if later on some of you feel that there is some question or the other which has been left unanswered, and you feel that there is a requirement for that question to be answered, we'll be putting forth our contact details. And if you mail it to us, we'll definitely try to answer your query. May I request now Mr. Harvinder Singh?
A very good afternoon to everyone. So, as we have heard Mr. Ahuja and the valuable insights on the today's scenario and the legal environment and the environment which is dynamic and regularly changing. So, I am being touching upon some of the areas of the legal health check, kind of bit deep dive, so that we can understand that how important those legal health checks are for a company, and if not followed, then what could be the consequences. So I'll be briefly touching upon, and I am being running through your presentation so that we can understand and have a deep dive on the subject. So let me show you the share the presentation with you. So I am sure that you are able to see this presentation, the slide one. Hello.
Yes.
Okay. Thank you. So historically, the boards and the management of the company were always worried to create more and more value for the shareholders, which is very true because they invested the money and they of course want value for their money. But at the same time, with the expansion, with the growth, now the focus is also changing, and now the regulator also want to have the value protection and value management in place, so that the corporates should not go on the wrong side of the law. So that's how you have been seeing that there are a number of changes in the laws. Even if I take in last 3-4 years, there have been drastic changes in the acts, which I'll be taking you through. The first being the Companies Act. With the advent of Companies Act 2013, the law has changed drastically with respect to compliance of the all applicable laws which are applicable to a corporate. So now it has been mandated by the statute, which is the company law, that you have to compulsorily comply with all laws, and onus has been put on the directors and the KMPs of the company, that they have to comply, make the systems and procedures, so that the compliance shall take place. And the listing agreement goes a bit further in this step. They also said that you have to do it periodically, you have to review it periodically, and then you have to report the non compliances and the corrective steps which you have been taking for those non compliances. And also, if the corporates are liable for all are liable for making the audit reports. The audit reports also now mention the about the compliances of law, and if you are subject to a sectoral audit, it requires beyond that whatever other applicable laws, whether you are following those laws or not. So these have been now made mandated by the statute, and there is no runaway or there is no leeway for the corporates to avoid these compliances. And also, if you see the all other acts, whether it is HR law, labor laws, whether it is environment laws, whether it is commercial laws, or laws related to corporate, or other laws, whether it is food related law, or banking sector, or legal methodology, all laws, if you see the penalty section, all laws enjoins responsibility on the directors and the officers in default. For example, in a factory act, the occupier has to be a director of the company. So if occupier is the director of a company, he can be liable for a penalty of about 2 lakh rupees and or an imprisonment of rupees of 7 years. So these kind of, and even for, if you see the Water Pollution Act, there the minimum punishment is about 1.5 years of imprisonment. So these are some of the changes and the drastic steps taken by regulator to bring the compliances in place. Now, even as Mr. Ojat informed, told us that courts have been time again also giving these strict measures that if you are not complying, if you are not following diligently the compliances of the corporates, then even if you are independent director, you cannot escape. We have seen recently in a Jayaprakash Associate case, and also in the case of Nirav Modi, where the personal assets of the independent directors have been freezed. So, courts have been also taking a strict stand against the non-compliances, against the frauds which have been done by the companies. So now, having said that, I would like to take you on the challenges which the corporates generally face while complying with the applicable laws. There are complex legal structures, there are multiple laws, there are wider coverage, there are multiple regulators. So sometimes the corporates are not aware that what changes are going through. And at the same time, there are stricter government regulations which are regularly aimed at prosecuting the people, and at the same time bringing lot many changes in the law. Courts are also taking strict actions. Pressures are also there from the international clients, those who are the export houses, or who have clients abroad. They also require that full compliance shall be in place. And then there are certain internal challenges also, that generally the internal teams, whether it is an in-house legal counsel or a CFO or a CEO, they are too much busy in their other important areas, that the lack of awareness somehow peaks in, and it is very difficult sometimes to follow those laws. And we have seen in the corporates that there is no centralization, because HR is taking care of HR related laws, finance team is taking about the finance laws, marketing is taking about their laws applicable, other production, logistic, they are taking care of their department. So there is no centralization, and also updation process is not robust, and there have been frequent changes in the processes, owners, there is turnover of the people, or there are internal processes. These are certain challenges which are sometimes posing a great challenge for the corporates to comply with the applicable laws. Now, you've been aware that there are, I was reading through a FICCI report. It was saying that there are approximately 150 laws, central and state laws, rules, and which are covering about 2000 compliances. The exact is 1984 compliances, but I have, for the sake of convenience, I have written 2000. So, these are several compliances which a corporate has to follow on a routine basis, regular basis, and this could be one time, this could be date based, this could be event based, and there could be some which are ongoing, because there are certain regular registers, records, filings, contribution payment, which you have to regularly follow. And if you don't follow these, then of course the result is imposition of penalties, prosecution of directors, occupiers. It could lead to stoppage of operations, vacation, disqualification of directors, cancellation of licenses, and loss of reputation. These are certain list of acts which is generally covered. I will be touching upon some of the few recent changes which have been brought. you know if you see in a Companies Act itself, in the last year 2019 till date, there have been many changes, whether it is reporting related to MSME or ultimate beneficial ownership identification, active filing, demat processes. Then CSR provisions. Earlier they were on the criteria of either you donate or explain, but now it has moved to either you donate or get prosecuted. And now even they are making provision that whatever fund you are not able to donate, then that fund has to be gone to the government fund, which they will be setting up soon. So there are loans and investment provisions which have been becoming. You have to follow that, because in the corporate structure which is well knitted with the related parties, you have to take care whatever loans and investment you are giving to the group companies, and there are related party transactions related to that. So in even if in the labor law and industrial relation, if you see, there are many changes which are going on. Even if for the purpose of Maternity Act, you have seen changes have brought in, the leaves have been increased, there have been made provision for the crutches. And then for the POSH also, Prevention of Sexual Harassment Act, there have been many changes. It requires trainings, it requires filings, it requires safety of the women employees. And then there have been recent judgment on the PF, which you may all have witnessed, have which have provided for changes in the salary structure of the organizations. So now government is also trying to ease out. They have been bringing various four codes to consolidate all those laws, but we have to see that how much it will able to help the industry going forward. Even if you see in the environmental laws, there have been drastic changes. The focus of the government has gone very much on the environment safety, whether it is plastic rules, groundwater usage rules, battery management, biomedical phase, e-waste. So these have been some of the new rules which government has brought in to save the environment. And then there are several other laws, whether it is Consumer Act, Legal Metrology Act, which deals with packaging of products, Bureau of Indian Standards, Information Technology Act, Food Safety Act. So there are several laws which a company has to face depending on which sectors they are dealing with, and how and what they have to comply on case to case basis. Further, of course, it says that compliance, we have to take compliance as a business enabler, not as a burden. So there are benefits also of being compliant. You have a good market reputation among the public, among your customers, suppliers. You have a fewer fines, penalties. In these cases, you save cost on these aspects. And also, if you see, the consequences are much grave and harsh, whether it is financial losses, reputational harm, loss of opportunity to the competitors, and talent retention. Because nobody, no directors, no CEOs, MDs would like to associate with a company which is tainted, which has a compliance issue or which has a governance issue. So how we can help on this is that we know how a compliance framework work and what are the essentials of the compliances. So we can help in bringing we have the inventory of the applicable laws depending on the location, businesses, central acts, state acts. And then we do a compliance health check proper. What is the current status of the compliance? What are the gaps which can be filled? And then discussion with the management, training can be done for the users. then how to prepare MIS reports so that you are able to present the real time basis what are the compliances going on and to deduct the non compliances at the right time, and then updating and monitoring because there are been ever changing in the changes in the law have been very regular. So updating and monitoring is also important part, and of course you can trust us for this. So I think that's the main part which we want to share with you, that why the legal health check is important and it should not be taken as a burden, and the non-compliance can cost cost a lot, and it would be wise that the corporate should take steps